The Help Center provides access to free information, advice, and limited representation to unrepresented low-income individuals of all ages who are facing eviction and other legal rental housing problems in Philadelphia. Prior to the establishment of the Philadelphia Landlord Tenant Legal Help Center, Ms. Cohen worked as the coordinator of consumer and tenant rights at Senior Law Center, a nonprofit organization that protects the rights of older Pennsylvanians. Ms. Cohen began her legal career in private practice, working at Wilson, Elster, Moskowitz, Edelman and Dicker, and Montgomery McCracken. Ms. Cohen received her JD from the Washington College of Law and her BS from the Pennsylvania State University. All right, thanks so much.
Thank you. Thank you. Hi again, I'm Michelle. It's nice to meet you. How many people are attorneys? Can you raise your hand? How many people have practiced in municipal court in Philadelphia? Okay. How many people have done landlord-tenant work? Oh, good. So it's a fair amount. This is going to be kind of a basic talk. We'll go through very quickly. We have tons of material. You can always contact me with specific questions. You can request. I have so much information that trying to condense this into an hour is very difficult for me. So again, I started the Legal Help Center in November through funding through my family initially, because there's so many people in Philadelphia that are not getting legal representation. Currently, there are 30,000 eviction cases filed a year in Philadelphia. And that's not cases where the tenants have a problem and want an opportunity to discuss the problem. That's 30,000 cases where there is, where the tenant is being sued. 85% of the cases, there's a landlord attorney that comes to court. In less than 3% of the cases, is the tenant represented. So you get into court and there's a clear imbalance of power, and I'll talk to you about the process. It's like, this is my contact information, and I can make this available, I can make the PowerPoint available to put on, I don't know if you have a community website. So the Help Center was created to provide, right now there's like 5 attorneys.
I'm taking your number.
Oh.
Thank you.
Okay. Professionals should use my cell phone or my email. Clients need to use the regular number, otherwise I will have clients calling me at 3 in the morning. That's what used to happen, so tenants are not supposed to call my cell phone. But I welcome professionals. I much prefer professionals to use the cell phone or the email. So right now in the city of Philadelphia, there's about 5 attorneys that do landlord-tenant work. I don't know, I think Kateria McCabe is part of your community. She works at the Senior Law Center. She does it half-time, and community legal services. So there's clearly not enough people doing landlord-tenant work. And the injustices that you see in court are just horrible. So my goal, I think we go down 2 slides now. So the goal is to provide information, because people always do better with information, a one-on-one consultation to provide them with information about their specific situation, and when needed, I go to court with people. Okay, we can actually move ahead. You know, if you're members of churches, I don't know if everybody's a member of this church. No, I don't think so. Okay. I'm happy to come out and talk to tenants and tenant groups and individuals, because part of my goal and part of my mission is to educate tenants so they know what they're supposed to do and what's not supposed to happen. So I talk about rights and responsibilities. So let's start talking about the landlord tenants. Just so you know, if I go like that, it's just to move the slide. It may look funny. Landlord-tenant relationship is a contract. And unless there's an overriding public policy, everything you need to know is in that lease agreement. So a lease agreement, let's say that's for a year. If a person continues to stay there, that lease still is in effect. So all the terms of the lease, so if only one person's supposed to be living there, then only one person's supposed to be living there unless you modify the lease. What typically happens is a tenant will sign the lease without seeing the place because it's a condition of, and they'll give them first, last month's, and security. Not allowed to give more than 2 months security, and question whether prepaid rent is security hasn't been decided yet. But you're only supposed to have 2 months of security, and then after the first year, you're supposed to get the 1 month back. I mean, yeah, after 1 year, you're supposed to get 1 month back. So when a tenant comes into you, you need to look at the lease. Oral leases are okay. Then you need to actually talk in terms of what is the agreement. And in an oral lease, it's not as crystal clear. So that really defines the rights and responsibilities. So the landlord will file, now everything's done electronically, the landlord's attorney will file a complaint on the municipal court website. And I'll show you at the end how to get to the municipal court website. You can find everything about a case on the municipal court website, whether you're licensed to practice in Philadelphia or not, like anybody can, which is a problem. You can also look and see if there's violations from licensing and inspection, and I'll show you how to do that at the end. So, client comes to you, the first thing you want to do is look at the lease. Contrary to what Pete says, I don't give them a voice. I don't want to hear the whole story because otherwise they'd be sitting there for 2 years. I say, when did you enter into the lease, what were the terms? I detail the conversation very clearly. And at the end, I do give them a voice. Because there's usually a lot of emotional problems, there's a lot of hurt feelings, there's, the tenants I represent are usually very poor. They're always poor, usually very poor. And they oftentimes have cognitive issues or language barriers. They're disabled in some way. And they're the people that get taken advantage of because they're least able to fend for themselves. So we start out, we look at the lease, we see when they moved in. On an eviction case, you can be evicted for 3 reasons. You're not paying rent, that's A. B is end of term. And C is a breach of condition of the lease. So most of the evictions we see are for A, for not pay. So then it's pretty clear. You look at the lease, how much you're supposed to have paid. You look at the receipts when they have them, which is always an issue. So you lease receipts, you net them out, and you know if there's a problem. It's really that simple, in theory. Tenants tend not to have receipts organized like we like. You can get a ledger from the landlord if he'll provide you with one. A lot of the landlords that I work with don't keep ledgers. They don't give receipts. They only accept cash. So there's some defenses that a tenant can have. Okay, so before they can be evicted, the landlord has to give them a notice to vacate. So that's one of your defenses on behalf of a tenant. As long as the lease doesn't say they don't have to, the law says they do. And so if they don't give a notice to vacate, the court doesn't even have jurisdiction to hear the case. Sometimes they'll say, get out in 5 days, and the law with non-payment of rent is 10 days. It's an improper notice to vacate. That is a defense. Municipal court judges don't necessarily agree, but it's a wonderful appeal issue. So that is a jurisdictional question. Okay. Landlords, this is the best area for tenants. Landlords need to be licensed in Philadelphia. I'm a business owner. I own a small law firm. I had to go get my business license. Okay, if you do business in Philadelphia, you need a business license. It's only $350 for the rest of your life of your business. It's not that onerous. So you need a business license. And then when you rent, you need to have a rental license. Renter's license is $50, and you need to get it every unit every year. It's not really that onerous. The landlords I deal with don't register as a business, and they don't get renter's license. Why? not for the $50 is because then that becomes income that they have to pay tax on, both federal, state, and city. So they rather fly under the radar. Well, when you play that way, there's penalties. Not supposed to collect rent. You don't get back rent if you paid it because the case law says it was a gift, some gift. But the first thing you want to do is see if the landlord had a license for the time that the tenant was renting. So you do that you can start by going on the LNI website and you'll see if they have a current license. But it may not tell you if they had a license, let's say they're looking for the last 6 months. The licenses run March to February of every year. So you can always call licensing and inspection through 311 and ask if there's a renter's license. No license, no rent. And I will tell you that the court enforces that one. The court enforces the business license and renter's license. So they can't file an eviction action without getting the license because the court checks it. But they may not have had a license for all the months that they're seeking rent for. This is the key. This is right now the greatest thing for me, the certificate of rental suitability. When you move into a place anytime after October of 2011, the landlord must get a certificate of rental suitability, which is a checkbox on a website. So they go there, they go to the website, they check that there are no LNI violations. And they get a certificate printed out, and then they must give you a booklet. They must give the tenant a booklet, which is in your packet, and tells the tenants the rights. I have yet to see one landlord do this, okay? Not one single landlord. I'm still waiting, and landlords will tell you they have it because they're confusing it with the renter's license. It's a certificate of rental suitability. So and you can't check it out with LNI ahead of time. So when you go in, you say to the landlord or the landlord's attorney, where's the certificate of rental suitability? We don't need one, that law's controversial. No, it's crystal clear. And the law is in your packet. No license, no rent. Okay, so I can't tell you how many thousands and hundreds of thousands of dollars tenants are saving when they know about this. Not that we want to advocate technicalities. The landlord bar will say it's a technicality. What's a technicality to one is a right to the other. We want the housing in Philadelphia to be habitable. It doesn't have to be perfect. There can be cracks in the hanging. It has to be habitable. And this is the way we're going to force it to be habitable. Lead inspection. This is a brand new law that has come out. If there are children in the house 6 or under, and landlords can't discriminate and not rent to people with children, by the way. 99% of it. There is one little exclusion that it would be a development. But if there's a child 6 or under in the house, the landlord must have a lead inspector come in and check to see if there's lead. And then they have to remediate if there is. This is really important because we don't want these children growing up with cognitive problems from the beginning. We want children to have the best opportunity to be able to function well in school and learn. Landlords are also not doing this. Again, not only shouldn't they collect rent, you should call the Board of Health. And they will come out and send somebody because that is taken seriously.
With those last two, is that preventing the landlord from evicting and collecting rent, or it's simply something they must address as part of the process?
The judges don't like this in municipal court. In my experience, and I know this is being taped, my experience is the judges are very landlord friendly. So I've had very few judges enforce the certificate of rental suitability, but what happens is when you appeal it, it gets enforced. And I'll go through the appeal process, which is really easy. It's a really easy process. So they will let them bring the case because the courts haven't started yet checking on these two. We need to advocate for that, but we have a list of issues that we address with the court, and it moves, slower. We're constantly trying to improve the system. You have a question? No? Okay. So if the tenant hasn't paid rent, and let's say they were unemployed, they had a family situation, and they didn't pay the rent, There are some places that you can get rental assistance. The Office of Supportive Housing is probably the best known. You actually may know of other private funding. Office of Supportive Housing gives you a one-time gift of some money, and it varies. It's $500 or $750 depending on what their funding is at the moment. They will, but the tenant needs to be able to pay the ongoing rent after it's cleared. So somebody that has no money, they're not going to give money because the next month they're going to have the same problem. And it's the last $500 or the last $750. So if you owe $2,000, they're going to wait till you pay down the balance. Oftentimes, the landlord bar will work with you. They work with me all the time. They're actually pretty great. The tenants, the landlords that are not represented, sometimes they work with you, sometimes they don't. It depends on how much they want this tenant to leave. If there is a judgment for money, if Philadelphia is a pay and stay. I'm not sure about Pennsylvania, but actually Pennsylvania is a pay and stay state. So as long as the tenant comes up with the money in the judgment, not ongoing rent, just the money in the judgment plus the writ fees, which are about $200. If you show proof to the landlord-tenant officer, which is the sheriff that enforces the eviction actions, if you show them proof that you paid or you give them cash right there when they come to evict you, you get to stay. If you enter into an agreement, and I'm going to talk about the process, if you enter into an agreement in court, you may or may not lose your pay and stay rights. We're waiting to litigate that. We're waiting for the perfect case. Every time I appeal it, the case settles, because the landlord doesn't want to fight it. But I'm really looking for the right case, because I don't think you should be giving up rights if you're entering into an agreement, especially a right that you don't even know you have. There is a domestic violence law. If somebody's a victim of domestic violence, they can break their lease. They need to have notified the government, the police or something, and there's a certain procedure, and it's in your packet. But there are some exceptions. You can break your lease to get away from the abuser, and you can't be penalized because you're a victim. So if the abuser comes and breaks the windows, landlord can't put you out because you're creating a nuisance because you're a victim.
With the domestic violence law, that's only allowing you to leave the property, not, I get to stay in the property and not pay rent.
No,
It was the abuser's responsibility, the husband-wife situation.
No, you still have to pay rent. You know, that would be unfair to the landlord. But there's certain provisions and to allow you to get away from the abuser, really. Anti-lockout law. This is a huge deal in Philadelphia. Landlords think if they don't want the tenant to live there anymore, they just change the locks. Or they tell them, you got 2 days to get out, I'm changing the locks. That is illegal in Philadelphia. It is illegal and there's criminal penalties. We're working with the police to enforce it, which has been a challenge, though the police are really working with us. If you have somebody that is locked out and you go on the municipal court system and there is no alias writ served by the landlord-tenant officer, it is illegal. You tell the tenant to go to the property, to call the police, that there's an illegal lockout, you ask for a street supervisor, you stand there, the police will literally stand there while you either hire a locksmith. Most of our clients do not have money for a locksmith. They can break back in. They are in possession of that property. It's like if somebody moved into my house without my permission, no, I can go back into my house. As long as you can show that you live there, like a driver's license, a PICO bill, or something that shows that you live there, the police will stand by while you break back in. And then somebody needs to be pretty aggressive with the landlord. Next one. Habitability cases. Landlords are required to provide heat continuously at 68 degrees from October to, I think, mid-March or the end of March. If your tenant does not have heat, you call L&I and you put it in as an emergency, and that's like one of the few emergencies L&I recognizes. 3 days, there'll be 3 business days, and they'll cite the landlord. They don't turn on the heat. But at least it gets the landlord's attention. And you want your tenant to document what the temperature is, because currently there's almost no lawyers that will affirmatively go after the landlord, but I'm thinking about doing that. It's actually, being a poor landlord is a violation of the Consumer Protection Act, and a tenant can get punitive damages. They can get treble damages, and under one of the other statutes get punitive damages. And as a way of teaching a lesson to some repeat offenders, I'm considering doing that, because I can tell you horror stories beyond belief. So habitability, there's a flyer in your packet that talks about how to handle repairs. You want tenants to do everything in writing. It sounds obvious. I don't know why tenants don't realize it's obvious. Text messages are fine because you can print them out. Email is fantastic because you can also see that they've received it. Not everybody has, smartphones and computers. So a good old-fashioned letter they need to keep a copy. So sometimes they send letters and they don't keep copies. So depending on how urgent, if it's, the handrail's a little wobbly, maybe I'd give them 2 weeks to fix that. No doorknob. I've encountered a lot of places in some of the worst sections of Philly where there's no handle for the door, so anybody can move in. I give them 24 hours for that. You call L&I. Again, it's 311. The risk of calling L&I is this. If the problem is really minor, you gotta be careful, because once you call L&I, the landlord gets angry, and they're not allowed to retaliate, but they do. So there is a law, an anti-retaliation law, but they do all the time. So you kind of have to pick and choose. I have some tenants that say, well, it needs paint, they didn't paint, landlord's not required to paint. And I have this little thing, this little hinge that squeaks, don't call L&I for that. If it's a safety issue, you call L&I right away. I would give the landlord like 2 days notice on a security issue. You have the right to fix it and deduct it after giving notice to repair and deduct under certain circumstances. But you could, if your rent's $500, you can only do a $500 repair. You can't do a $1,000 repair. So you may have to say, well, fix this door this month and that door next month. But on landlords that aren't fixing things, they usually don't have the license, so that the tenant's paying money that they don't even need to pay. The other thing is tenants that have complained about habitability issues and they don't want to pay rent, they need to tell the landlord why they're not paying rent, and they need to put that money aside. They don't have to put it in an escrow account. One law says you do, but there's another law that says you don't. It has to be in a separate place. You can't spend the money, okay? So what I tell tenants is go open a separate account, and if the repair situation gets bad enough, take that money and use it to move. But again, we want to constantly write the landlords, let them know the problems. Pew versus Homes is just a big case on it. Utility shutoffs. Part of the illegal lockout law is you cannot turn off somebody's electric. You can't take the front door off the premises. You can't shut off utilities. Oftentimes utilities are shut off by landlords. Now there's various reasons. One is they didn't pay the bills, the gas, electric, or water bill. That's an easy one. If that's why the water's off, you're happy. You go with the lease to show that you're not responsible, that you're a tenant and you're not responsible for the water. You go to the water company and you say, I want to exercise my USTRA rights, and there's a pamphlet in your booklet. Your USTRA rights. The utilities, if there's a tenant in the property, the utilities are required to give the tenant notice before it's shut off. They never do, because how do they know if there's a tenant in there? So you go in and you exercise your usher rights, and as long as you pay that month's bill for that usage, for that month only, not the prior arrears, they will turn on your electricity, your gas, and your water. The problem comes is when the landlord goes into the street and turns it off himself, or the heater's broken, or they turn the gas off inside the house. That's a bigger problem. I would call the police on that, and I would call 311. Okay. Those were my densest slides. Okay. Hearings in municipal court. Let's talk about the process a little bit. Tenant gets served, and they can get served by personal service, like actually somebody handing it to you or posting it on the door, okay? So if there's a 500-person building, they can post it on the outer door, and that's considered posting. So you may never see it. But okay, so there's an eviction complaint filed, and there's a date, usually like 3 weeks out. It's either in the morning or afternoon list. It's always in room 3 at 1339 Chestnut Street. If that date's not good for you or for the tenant, you have to request a continuance in a letter to court administration 10 days ahead of time. Otherwise, they will not, for a tenant, they will not consider it and, until the day of court. And of course, then you run the risk of it being denied. And they're often denied. They give professional courtesy to attorneys, not so much to tenants. So you get to court, you gotta get there on time because court starts at 9 and 1, not 9:01. People are in default at 9:01. So you run the risk in Philadelphia where tenants oftentimes have young kids and they can't drop them off at school until 8:30, and court starts at 9, and that's not always enough time to get downtown. It's a real problem. Court starts at 9:01. You may want to call the court if a tenant has kids to drop off, and write a letter and say they'll be late, and maybe they'll hold it until 9:15 for you. So you have a court administrator comes out and calls the list. The landlords come up with their cases and they call the list. And then they have everybody go back and speak to the landlord's attorney. Here's the inequitable power. So usually a guy in a suit, it's almost always a guy in a suit, calls you and says, Joe Smith, you come with me. And you go and you sit at a little desk where the lawyer has a court-provided computer and sits and says, okay, when do you want to get out? Or when do you want to pay the money? Let's make an agreement. Or I'm going to, get you escorted out. And they type up an agreement. The tenant never sees a judge. They go to another court employee who says, this is what you agreed to. You agreed to this? Okay, it's not appealable. Sign, you're done. That's their day in court. That happens in over 90% of the cases. So you have a tenant who has no idea what their rights are, no idea what their responsibilities are, meeting with the landlord's attorney. Now, many of the landlord's attorneys are very fair, but nobody's telling them about these rental license and the certificate of rental suitability. I assure you that would never come out of a landlord's mouth. Nor should it. They're not the lawyer. They're the lawyer for the landlord. So that is a big problem. That is why we need people in court. So tenant goes without an attorney and says, oh, okay, well, no, I didn't pay rent. There's no heat. Okay, well, if it's so bad, then why don't you agree to leave? So we'll put a judgment down for $2,000 and you'll leave in 21 days. Everyone gets 21 days. I go and I say, where's your certificate of rental suitability? You don't know any rent. Listen, you fix the heat. Or what's it? And so if we take it to court, what happens? Okay? Let's say that the landlord bar, I've tried maybe 5 of these against the landlord attorney because we all know the law. So it's very easy to work out when everybody knows has the same information. It's when there's the landlords that are not represented. And so what typically happens is, no, I want all the rent. Well, where's your certificate of rental suitability? I don't have it. Or, oh, I have it here, and they give me the rental license. I say, it's not the certificate. well, I want my money and I want them out. I said, okay, let's go before the judge. We go before the judge. Half the time I'll win and half the time I'll lose. Okay, I win, perfect. If I lose, you have a right, every party has a right to an appeal. Fill out an IFP so they don't have to pay anything, and I've never had an IFP declined on any of my clients. You know, they see my name, they know I've already screened them. I work with 200% of poverty or below. But I'd say the far majority are 100% or below. So you appeal it. Now the landlord needs to hire an attorney and an expensive attorney. So $1,000, $2,000, maybe $3,000 to handle the landlord-tenant action. All of a sudden, it's really easy to negotiate with them. You know, and my services are free. So I do the appeal. Once I do the appeal, got to serve it on the landlord, not the landlord's attorney if there's an attorney, on the landlord. Though I do a professional courtesy to the landlord's attorney. They don't want to pay a lawyer. So what I do is I tell my clients to move, which is not very easy in the city of Philadelphia. But they move, then the landlord has no incentive to spend $2,000 to get $1,000. No incentive whatsoever. They have to file a complaint within 20 days. They don't do that. Then you have to do your 10-day notice of default like any other civil process. And then you do a non-pros. So that means you win in common pleas court and they vacate the landlord-tenant record judgment. So now your tenant doesn't have a record. So that's actually a pretty easy procedure. Let me just make sure.
Can I ask you a real quick question?
Absolutely.
All of my clients have landlords with P.O. boxes. So how do you serve the landlord?
You are required, part of the licensing, you're required to have an address where you get mail if you run a business in Philadelphia. Okay? So you look there. You could look on the deed, and the recorder of deeds, well, I have access to a website, but you can call the recorder of deeds to find out where the owner of the
So you
property
can do
is.
that because a lot of times the name of the landlord on it is not the person who's on Philadelphia.
That's right. That's right. It's a whole scam. So I've had problems where I've had a landlord sue my client, okay, in eviction. Okay, when we appeal it, we use that address and to serve them, and they say no. There was no service. You try every which way, and then you do a petition for alternative service.
Michelle, doesn't the tenant have to post the rent that's due if there's a judgment in it?
Well, actually, I'm going to get into that. So if a tenant gets a judgment in municipal court, okay, it's the next slide. Go to the next slide, and then we'll come back to this one. So let's say a tenant appeals, okay? Again, I assume you all represent low-income people? Okay. There's a special rule in common pleas court where you don't have to put all the judgment in escrow. You only have to pay, when you file the appeal, 1/3 of your rent that's due for that month. 20 days later, 2/3, and then 10 days later, the full rent, and then every 30 days, not every 31, not every 28, not once a month, but every 30 days, the current rent gets placed in escrow in the Court of Common Pleas, okay?
But most of the folks we're representing can't do that.
Well, they can, because it's not back rent, it's current rent. So they should be paying, they should be paying the rent, or be putting it aside anyhow, because you don't get to live in somebody's property for free.
You'd be surprised how many folks try.
Well, yes, no, I'm not surprised. Yes, that, and talking about, like, I know your focus is very calm and gentle. I'm not calm and gentle at all. I really read the rights to the tenant. If they're living in a place and not paying rent for no reason, no, you can't do that. I know you're poor, but that's not the way the system's designed. So I'm really clear. You either go out and get a job, you get some family money, or you move into a shelter. You know, they're the hard facts of life. You cannot stay in somebody's house, and I won't take a case if a tenant says, I'm staying there, I'm just not paying rent, unless I have a defense. Because I'm not a social worker, even though I will tell you, on the cases where it calls for real social work, I do it. Like I have a blind client now that is completely blind, has been blind since birth, and she was sued for eviction because she wasn't keeping her property nice. Well, you can imagine how hard it is to wipe up spills when you don't know they're there. The apartment house had a real right. Other tenants were very upset. There was smells coming from her apartment. I was able to get PCA to come in, and she's now part of the waiver program. And I spent hours upon hours. I got her signed up in an expedited way for the waiver program, where now somebody comes in and not only do they clean up the little messes, but they read her mail. She brought a suitcase of mail because nobody was reading her mail. And I spent like 2 hours going through, she had checks. She had nobody to read her mail. Oddly enough, the Association for the Blind would send written mail. And I'm thinking, like, if anybody should be sensitive to this, she was completely blind. So now somebody is going in. So I'd like to deal with clients holistically. I can't force somebody to get a job. I can't force somebody's parent to take them in. I can lead them to services, and I really do try to lead them to services. Because the far majority of the clients are disabled, either cognitively or physically. Some can work, some can't. And oftentimes there's a lot of children involved. So I do try to refer out, but if they can't pay the ongoing rent, they need to leave. So to get what's called the supersedious, you pay the 1/3, 20 days later the 2/3. And so that gets deposited into the court. So what will happen is, let's say the landlord does file a complaint, which I think I've seen 2 of them. Then there is a program through Deckard set up, which is a big law firm in the city, where there's a mediation process that is a bit more fair. And if not, if a landlord files a complaint, and I believe in the case, I ask for a jury trial in my answer. Boy, that changes mine. First of all, you get the court really angry because they don't want a jury trial. But let's face it, that's our system. They're entitled to a jury trial. So I've had attorneys, I had a woman who had a newborn, was pregnant, and the landlord said, you either sleep with me or I evict you and your kids. I would have liked to take that before a jury. I could tell you horror stories. I had another blind man who was evicted with his kids because he complained that the sole toilet in his unit was not working for weeks. He had to keep going up every time somebody had to go to the bathroom, they had to go to a neighbor's. I see some horrible situations in Philly. So the notice to vacate, supersedious process, rule to file complaint. So what you do is when you appeal, it's a 1-page appeal and a rule to file a complaint. If they don't do that, you non-pros them. There's a settlement hearing and a jury trial. So let's go back up to what happens if your tenant is late. Your tenant is late, they get there at 9:01, there's already a default. You have to file a petition open judgment, which is really easy. You title the petition open judgment and you say why they were late, and it's pretty easy on that fact. So the bus was running late, all of that is accepted. That's pretty easy for municipal court. But there's 2 judges that decide these. One of the judges is extremely difficult, and you need to put in what your defense is, and you have to show paperwork, and if you don't, it'll get denied. Then you need to appeal it as an appeal of a supplementary order to the Court of Common Pleas, and that is really a pain, because you may end up having to do it as emergency because their process takes like 120 days. It's a lot of paperwork. You're in that situation, call me, I have templates for everything. So there's no reason to recreate the wheel. If you make one one of these agreements and somebody doesn't keep it, the other side files an affidavit of breach, which is basically, didn't pay the rent as agreed. If you disagree with it, you file a counter affidavit. No, I paid it as agreed, see attached receipt. It'll go to a hearing, and almost as if it's like a regular, just landlord-tenant hearing. Don't forget anything you file, you want IFP petitions. As a legal service agency, you may, if you're doing it through the legal service agency, there is a rule in common pleas, you just say, you know, they qualify for our services, you don't have to fill out that 13-page form. The 13-page form is really easy, but it is cumbersome. You have to write the name and address of your client like 8 times. I mean, by the end, I don't even have to ask them, you know, I know the name and address and the phone number, but it's an easy form, it's just cumbersome. But if you're through a non-profit, I don't think you have to fill it out. Whether you have a judgment, not a judgment, whether your tenant has a judgment, not a judgment, or you enter into agreement, if there's any money, once it's paid off, you need to have the judgment mark satisfied, or it stays on your credit, or it stays on the tenant's credit report. Landlord bar knows all about it. Once you show them proof it's done, they'll do it. But pro se landlords do not. You can always do a petition to have it marked satisfied. If I have a tenant who owes money, and they owe money, and they're going to move because they can't pay it, I tell them not to pay any of the money until they have it all together, and then come back to me, and I will give the money to the landlord with the paper to file. Because if your judgment is $2,000 and you pay $1,500 of it, it stays on your credit report for $2,000. So you might as well get it done and get it done right. Excellent. Okay. Let's say you get a judgment against you, you have no grounds for appeal. It's one of these really bad situations that always tugs at my heart. Landlord cannot get the first writ of possession. They need 2 writs to get you out. You get the court order, 11 days later, they can file for the writ of possession. They may do it on the 11th day, they may do it on the 30th day. They can't do it until the 11th day. So you don't know when they're going to do it. The landlord-tenant officer will then come post a notice on your door again, set at the tenant's door saying you need to move. And then 10 days later, they can get an alias writ. So theoretically, they can be evicted in 21 days. It never happens that fast. But the minute you tell the tenant it's not going to happen that fast, it'll happen that fast. So, 21's the legal earliest. But once they get the alias writ, then it has to go to the landlord-tenant officer, Mr. Messerman's office. Then they have to schedule it. And that takes a week, 2 weeks, sometimes 3 weeks, depending. During the winter, it was kind of crazy. And tenant gets no notice of it. So you guys can call and say, what's the lockout date for so-and-so? So I tell the tenant, it's a horrible process to have somebody knock on your door and say, out, and change the locks with all your stuff in. You want the tenant to start packing, and even if they have nowhere to go, you want them to have their medicines, the school uniforms, the books. So when he comes, they give you 10 minutes. They don't let you pack that. You're out. Okay. So with that said, there is an abandoned property law. I almost finished yet. There is an abandoned property law, which says, and this is a new law, once you're evicted, legally evicted, within 10 days, you have to give the landlord a letter saying, I want to come back in and get my stuff. Within those 10 days, if you come in, it's free. The landlord can't charge you anything. If you can't get it within the 10 days, if the landlord chooses, they can have it boxed up and put in storage for 30 days from the eviction. You would have to pay the storage fee and the packing fee. That law's in your packet. That is the law, so you have a right to come back in and get your stuff, and that's not just an hour or half an hour. The court will let you back in for 4 or 5 hours, but not to live, just the pack. Security deposit law we talked about. When a tenant moves out, they need to give the landlord written notice of some kind where to send the check to. It doesn't have to be your new address, it could be anywhere. Once they do that, they have 30 days and tick tock, because they don't give you a list of damages within the 30 days, tenant's entitled to double damages. And they can't say, well, you know, we had all these damages. No, no, no. Your time is in that 30 days. Commission on Fair Housing. It's actually a really good asset for tenants in Philadelphia. It's somewhere like 4th and Walnut. It's in the Curtis building. If a tenant has problems with their unit that the landlord's not fixing, they have to call L&I. Once L&I issues a violation, and L&I comes out in 30 days. Once L&I comes out and issues a violation, if you can show you're either current on your rent or do not have an obligation to pay rent, or it's an escrow, so if there's no rental license, you don't have to pay rent. You file a complaint with Commission on Fair Housing. They are very tenant friendly. They are much more tenant friendly than municipal court. So let's say you do that, it's a race to the courthouse. So the tenant wants to get to the Commission on Fair Housing before the landlord files in municipal court, because wherever the filing is first gets to hear the case first. And significant difference in results. Credit reports. Once everything's paid off, or if oftentimes we get into a client will leave in 10 days, no money judgment. I give them a form and it's in your packet for them to check their credit report. It's free. Don't let them pay for anything. You get one free credit report from each of the 3 agencies once a year. You guys should check your own credit. Make sure nothing's on it. Oh, I have credit reports twice. Oh, sorry. Key websites. Okay. I think it's in your packet. Okay. The key ones are courts.phila.gov. And you'll see the top right will be online services. You can pull down municipal court, you can pull down civil. Municipal court, it's really kind of self-explanatory. You can look up any case and find out what's going on. And then once you open up the docket, there'll be a little sign and you can click on that and it'll open up the actual thing that's been filed and you can read it without any problem. You can use that for the civil docket in the Court of Common Pleas, but you can't actually see what specifically has been filed unless you pay, okay? Or you can go down to the court. L&I, they just came online about a year ago. So if you go to phila.gov, I don't know how to do this. On the far right, halfway down, it'll say departments. You bring down L&I. And then on the far left, you'll be able to put in an address. And you put in the address, you can see if there's current violations and whether they have a license.
What kind of license? Business or the certificate?
The rental. They'll have the rental license on there. They will not have the certificate of rental suitability. L&I doesn't even know if they have it. The system's pretty new and not very efficient. So I encourage everybody to really think about taking cases in this area. My mission is to try to take any case that can come in that has any bit of merit, doesn't have to be perfect merit. Monday, Tuesdays, and Wednesdays. Of course, Community Legal Services has their case. I'd love people to be able to take cases Thursday and Friday. I'd be willing to mentor anybody. I'm at the point where most of these cases, I can talk to the person for 20 minutes and go into court with them, and it's really a finite experience, but it is life-changing. Yeah?
Do you do anything as far as with the foreclosure of?
Well, I don't do anything. There's a whole big infrastructure in Philadelphia for foreclosures. But let me talk about foreclosures for a minute. Let's say a tenant is in a foreclosed property. There's a law out there. And if they are what's called a bona fide tenant, so it's not like somebody's sister, they have the right to stay there in most situations for 90 days. And that's 90 days from when the property is transferred to the new owners. So, you know, if you face that situation, I haven't been facing it as much. I was facing it for a while, a few years ago. You can always, and I can send you the law.
How does all this play out when the landlord is PHA?
Not much different. PHA is supposed to be kind and gentle. My experience is each of the individual attorneys are very nice. Not as kind and gentle. It's not run like a well-oiled machine. So I have a relationship with one of the attorneys that I can kind of navigate the system a little better. A guy named Roger Chaffray, I don't know how to say it's French, but and he's fantastic. PHA does not like to enter into real agreements. I've watched PHA evict people for $1. You know, you sit as a collective pause when it says $1 plus, you know, the 83, and you're always ready to get out my checkbook, but then, you know, the 83 fucking costs add up, you know, so if you have 10 of them, it gets a little expensive. But for $1, so to me, $1 is somebody making a math error. Again, they get to pay instead. So PHA is getting more and more and more aggressive, where evicting anybody that's had any criminal history. So I had one client, this is like 5-6 years ago, who got into PHA through a prisoner's program, or like a prisoner's release. So he was involved in a murder 20 years ago. He did his time. He did the halfway house, and he got in. He's model tenant. He helped every senior in that building, you know, get groceries when they couldn't get groceries. He worked as a volunteer in a senior model. The landlord was crying at the hearing, but PHA was making them a victim. I represented him. This was like my best day in court. So packed courtroom, and I'm hearing this case, and the landlord said, yes, I'm required to file this eviction. You know, it was easy to read between the lines. She didn't want him evicted. And when we won the case, the whole courtroom got up and left. Yeah. So they're getting more and more aggressive. So they're not supposed to go back prior to 3 years, for criminal histories, but they tend to be fairly aggressive. And if you owe any money to any PHA building or Section 8 building, you got to clear that up. So if a tenant, let's say, either not as much owes money but has a breach of condition, let's say they had too many people living in the place or they didn't recertify, we got to get that judgment vacated before they can get back in the PHA. And I'll help people do that also. I do that all the time.